They saw a quiet old man and assumed he was an easy target. They didn't know they were picking a fight with a retired master surveyor who knew the county maps better than the city planners did. When the HOA president ordered a gazebo built 6 feet over his property line, she thought she was improving the neighborhood's value. She had no idea she was handing him the blueprints for her own financial ruin. If you enjoy watching arrogant boards get dismantled by the very laws they try to weaponize, settle in. This one is for the books. The sound wasn't what woke Arthur Vance. He was a man of routine, and his internal clock always pulled him from sleep at 5:30 a.m., regardless of the sun's position. No, the sound was what ruined his coffee. It was the distinctive hydraulic whine of a mid-sized excavator. Arthur stood in his kitchen, the ceramic mug of black roast warming his calloused hands, and stared out the bay window. His property, a generous half-acre corner lot in Oak Ridge Estates, was his sanctuary. He had bought it 20 years ago specifically for the drainage gradient and the precise sight lines to the tree line. He knew every inch of this dirt. He knew it because he had surveyed the original plat himself back in the late 90s, long before the developer sold out to the corporate management company that now ran things. At the far southeast corner of his yard, right where his meticulously maintained fescue grass met the wild buffer zone of the community park, a yellow Caterpillar excavator was tearing a jagged wound into the earth. Arthur set his mug down on the granite counter with a deliberate click. He didn't rush. He didn't shout. He walked to the mudroom, put on his boots, and grabbed his windbreaker. He didn't need a weapon. He needed clarity. He walked across the lawn, his eyes scanning the ground. He was looking for the visual cues he had verified just last spring. The orange plastic flagging tape was gone. The wooden lath stakes he kept near the boundary were missing. "Morning," Arthur said, his voice carrying over the idle rumble of the diesel engine. The operator, a young man in a neon vest and a dirty hard hat, throttled down the machine and slid the window open. "Help you, Pops?" "You're digging on private property," Arthur said. He pointed a steady finger at a patch of dirt about 10 feet to the left of the bucket. "The property line is right there. You're 6 feet over." The operator sighed, wiping sweat from his forehead. He reached into the cab and pulled out a crumpled set of blueprints. "Look, buddy, I just dig where the flags are." "Green flags say dig. I'm digging." Arthur looked. Sure enough, fresh green surveyor flags had been stuck into the ground. His ground. But they were wrong. They were hilariously, impossibly wrong. "Who set those flags?" Arthur asked, his voice tightening. "Project manager said the HOA president came out and marked it herself yesterday," the operator said, checking his watch. "Said something about reclaiming community assets. Look, if you got a beef, take it up with Linda. I'm on the clock." Linda, of course. Arthur watched the bucket scoop up another load of his soil he had amended with compost for 5 years to support the hydrangeas that were now being crushed under the tracks. He felt a spike of adrenaline, the kind he used to get when he caught a developer trying to cheat a setback line. "Stop digging," Arthur said. It wasn't a request. "Can't do that," the operator said, reaching for the throttle. "Schedule's tight. Grand opening is next month." Arthur didn't argue further. He turned around and walked back to the house. The engine revved up behind him, the sound of tearing roots following him like a taunt. He entered his study, a room smelling of old paper and cedar. He bypassed the computer and went straight to the large fireproof safe in the closet. He spun the dial, left, right, left. The heavy door swung open. Inside weren't guns or gold bars. There were tubes, rolled schematics, Mylar maps. Arthur pulled out a tube labeled Oak Ridge, Phase 4, Final Plat, 1998. He unrolled it on his desk, weighing down the corners with brass compasses. He traced the lines with a finger that shook slightly, not from age, but from a cold, simmering rage. He found Lot 44, his lot. He found the easement definition. There was no ambiguity. The HOA had no claim to that land. Linda Halloway hadn't hired a surveyor. She had likely walked out there with a measuring tape in a sense of entitlement. A notification chimed on his phone. It was an email from the HOA portal. Subject, Notice of Community Improvement Project. From Linda Halloway, President. Dear residents, work has begun on the new East Side gazebo. Please excuse the noise. Also, a reminder to Lot 44, Vance. to remove personal plantings that encroach on the new construction zone immediately, or fines will be levied for removal. Arthur read the email twice. She was building on his land, destroying his property, and threatening to fine him for the privilege. He looked at the map. He looked at the heavy brass plumb bob sitting on his shelf, a relic from a time when measurements meant something. "Okay, Linda," Arthur whispered to the empty room. "You want to play by the rules? Let's see if you can read them first." He didn't reply to the email. He reached for his phone and dialed a number he hadn't called in 3 years. "Hanson Forensics," a gruff voice answered. "Jim, it's Arthur," he said. "Dust off your total station. I need you to certify a crime scene." The Oak Ridge Community Center always smelled of lemon floor wax and stale indifference. It was Tuesday night, the monthly congregation of the Homeowners Association, a ritual Arthur usually avoided like a root canal. Tonight, however, he was the first one through the double doors, carrying a black architectural tube under his arm, like a soldier carrying a rifle. The room was set up with 50 folding chairs facing a long table draped in a cheap blue cloth. Behind it sat the board members, looking important in their name tags. In the center sat Linda Halloway. She was reviewing a stack of papers, highlighting items with an aggressive neon yellow marker. She didn't look up when Arthur took a seat in the front row. By 7:00 p.m., the room was half full. Most residents were there to complain about trash pickup schedules or argue about the color of their mailboxes. Arthur waited. He possessed the patience of a man who had once spent 3 days in a swamp waiting for water levels to drop just to measure a culvert. "New business," Linda announced 40 minutes in, her voice amplified by a slightly feedback-heavy microphone. "We are happy to report that the East Side Gazebo project broke ground yesterday. It's going to be a beautiful addition to our property values." A few board members clapped politely. Arthur stood up. "Madam President," Arthur said. His voice was calm, baritone, and carried without the need for amplification. Linda peered over her reading glasses. A flicker of annoyance crossed her face. "Mr. Vance, I assume this is about the construction noise. We are within the city ordinance hours." "It's not about the noise, Linda. It's about the dirt." Arthur walked to the side of the room where an easel stood, intended for presentation charts. He uncapped his tube and withdrew the 1998 final plat map. He pinned it up with practiced efficiency. The Mylar sheet was old but pristine, the lines sharp and black. "This is the certified survey for Phase 4. Arthur addressed the room, not just the board. "I was the surveyor of record. If you look at the monuments here and here," he pointed to 2 distinct corners of his lot, "and cross-reference with the iron pins I located this morning, the community easement ends 10 feet from the curb. Your construction crew is pouring footers 6 feet past that line. You are building on private property." The room went quiet. A few neighbors craned their necks to see the map. Facts have a way of silencing opinions, and the map looked official. Linda didn't look at the map. She sighed loudly into the microphone, a sound that popped through the speakers. "Mr. Vance, please take that down. We are living in the 21st century, Linda said, her tone dripping with condescension. The board used the county's GIS overlay on the iPad. It clearly shows the green space extending to the tree line. Your paper map is outdated. GIS overlays are approximations," Arthur said, his grip tightening on the easel. "They can be off by 10 to 20 feet. They are for tax assessment, not construction. You cannot build a permanent structure based on a website screenshot." "We hired a contractor, Arthur. They know what they're doing," a board member named Steve piped up from Linda's right. Steve was a retired car salesman who always agreed with Linda. "Your contractor is digging where you told him to dig," Arthur countered. "I am telling you, as a licensed professional, you are making a mistake that will cost this association thousands of dollars to fix. I am asking you to halt construction for 48 hours so we can have a joint survey done." "Denied," Linda said instantly. She banged her gavel, a ridiculous wooden prop she had bought online. "We are on a tight schedule for the summer solstice party. We cannot stop every time a resident gets confused about their property lines." "I am not confused," Arthur stepped toward the table. "I am warning you." "You are out of order," Linda shouted. She reached for the small control box on the table and pressed a button. When Arthur spoke next, his voice was just a voice. The room's speakers had cut out. "This is encroachment, Linda." "And this is harassment," Linda shot back, her voice booming over his through the PA system. "If you continue to impede the workers or disrupt these meetings, the board will levy a fine of $500 per incident for obstruction of community improvements. Check your bylaws, Arthur. Clause 14.2. She looked at the rest of the room, smiling tightly. Next item, the debate on beige versus taupe for the clubhouse trim. Arthur stood there for a long moment. He looked at the map he had drawn by hand 20 years ago. He looked at the neighbors who were now avoiding his gaze, afraid to catch the president's eye. He didn't scream. He didn't flip the table. He calmly unpinned his map, rolled it up, and slid it back into the black tube. He capped it with a snap that sounded like a gunshot in the quiet room. "Make sure you minute that," Arthur said to the secretary, a nervous woman typing furiously on a laptop. "Make sure you write down that I offered a joint survey and was refused." "Sit down, Arthur," Steve hissed. Arthur didn't sit. He turned and walked out the double doors. The cool night air hit him, washing away the smell of floor wax. He walked to his truck, tossed the map onto the passenger seat, and sat in the darkness for a moment. They wanted a war. They thought he was just an old man with a piece of paper. They didn't understand that he wasn't fighting for the dirt anymore. He was fighting for the truth of the line. He pulled his phone out and dialed the number for his attorney. It went to voicemail. "Sarah, it's Dad," he said, watching the lights of the community center reflect in his rearview mirror. "I need you to open a file, and I need you to find me the nastiest liability clause in the state property code. We're going hunting." Silence. Arthur had learned over 40 years of marriage and land disputes, was often louder than a scream. For the next 3 days, the residents of Oak Ridge Estates saw a different Arthur Vance. He didn't stand at the property line shouting at the foreman. He didn't storm into the HOA office. He simply sat on his back porch in his wicker rocking chair, drinking coffee and reading the newspaper, while 20 feet away, heavy machinery tore his backyard apart. To Linda Holloway and the board, this looked like submission. They assumed the threat of fines had cowed the old man into obedience. They didn't notice the new additions to the eaves of Arthur's roof. 3 high-definition, solar-powered security cameras were now trained exclusively on the southeast corner of the lot. They recorded in 4K resolution, capturing audio and video, backed up instantly to a cloud server. Every shovel of dirt removed, every boot that crossed the invisible line, and every crushed azalea bush was time-stamped and archived. On Thursday morning, while the construction crew was on a lunch break, a white van with no logo pulled into Arthur's driveway. A man stepped out, carrying a bright yellow tripod and a robotic total station, a piece of surveying equipment worth more than most cars in the neighborhood. This was Jim Hansen. He moved with the efficiency of a man who charged by the hour. He didn't wave to Arthur. They simply nodded. Arthur stayed on the porch. He wouldn't interfere. This had to be independent. Jim set up the station over a control point in the street, a magnetic nail driven into the asphalt 10 years prior. The robot spun silently, its laser eye scanning the terrain. Jim walked the property line with a prism pole, tapping the data collector screen every few feet. He reached the construction zone. The foundation trenches were already dug. Rebar cages were tied and sitting in the dirt. Arthur's dirt. Jim placed the tip of his pole directly on the edge of the trench, waited for the beep of the laser, and recorded the shot. Then he moved to the other side. 20 minutes later, Jim walked up to the porch. He didn't smile. He handed Arthur a printout from the field controller. "It's worse than you thought, Art," Jim said, lighting a cigarette. "The old iron pin is gone, dug up. But based on the street monuments and the rear easement catch basin, I've reestablished the corner. They aren't 6 feet over." Arthur looked at the data. 7 feet, 4 inches. "At the furthest corner, yes," Jim confirmed. "And they've severed the root system of that 60-year-old oak tree. That's going to die in a year, maybe 2. Can you have the stamped plat ready by Monday?" "I'll have it by Friday afternoon. Certified, sealed, and ready for a judge who knows how to read," Jim promised. He packed up his gear and left as quickly as he had arrived. Arthur went inside and checked his email. A message from Sarah had arrived. The subject line simply read, "Gotcha, Dad," the email read. "I pulled the permits from the county clerk's office. You were right. They didn't file for a structural addition. They filed for a Class B landscaping improvement. That doesn't require a site survey or a setback inspection. If they pour concrete on a Class B permit, it's an automatic code violation. The fines start at $1,000 a day. Do not stop them. Let them pour. S. Arthur leaned back in his chair. It was a trap, and Linda had walked right into it. If he stopped them now, they would just move the gazebo back 10 feet and refill the hole. They would lose a few $100s in labor, and he would still be the neighborhood pariah. But if they poured the concrete, the sound of heavy air brakes hissed from the street. Arthur looked out the window. Two massive cement mixer trucks were backing down the cul-de-sac, their drums turning slowly. The foreman was shouting orders. The chute swung out. The gray sludge began to flow into the trenches dug on Arthur's land. It covered the spot where his prize-winning hydrangeas used to be. It solidified the encroachment from a mistake into a permanent structure. Arthur watched the stream of concrete flow. To anyone else, it looked like destruction. To Arthur, it looked like leverage. He picked up his phone and opened the camera app, zooming in on the license plate of the concrete truck, then panning over to the foreman holding the hose. "Pour it deep, boys," Arthur whispered, taking a sip of his lukewarm coffee. "Make sure it sets real hard." He wasn't going to interrupt them. He was going to wait until the last shingle was nailed to the roof. He was going to let them spend every dime of the budget, and then he was going to make them pay to tear it all down. The structure rose quickly, a skeleton of pressure-treated pine that smelled of chemicals and arrogance. Within a week, the roof was framed, blocking the morning sun that used to hit Arthur's kitchen table. It was an octagonal monstrosity, far too large for the space, looming over his backyard like a guard tower. The noise was constant. Hammers, saws, and the banal chatter of the work crew filled the air from 7 in the morning until 4 in the afternoon. Arthur kept his windows closed. He continued his routine, tending to the parts of his garden that hadn't been annexed, acting for all the world like a man who had accepted his defeat. On Tuesday, the mail carrier, a friendly woman named Brenda who had known Arthur for years, handed him a thick envelope with the HOA crest embossed in gold foil. She gave him a sympathetic look. "Another one, Mr. Vance?" she asked quietly. "Looks like it, Brenda. Thank you." Arthur took the envelope into his study. He didn't rip it open. He slit the top edge carefully with a letter opener, preserving the postmark date. He unfolded the letter. It was printed on high-quality linen paper. Invoice number 4022, re community restoration fees. "Mr. Vance, it has come to the board's attention that excessive mud and debris have been tracked onto the community cul-de-sac from the construction access point adjacent to your property. While the construction is for a community improvement, the proximity of your unkempt landscaping to the work zone has contributed to the soil runoff. Pursuant to Bylaw 18.4, Maintenance of Curb Appeal, you are hereby assessed a fee of $450 for pressure washing services required to clean the street. Payment is due within 10 days to avoid interest and potential liens. Sincerely, Linda Halloway, President." Arthur read the letter. Then he read it again. A low, dry chuckle escaped his throat. It wasn't a laugh of humor. It was the sound of a trap snapping shut. They were charging him for the mud their trucks had tracked out of the hole they dug in his yard. He walked over to his computer and opened the folder labeled Evidence. He clicked on the video file dated 3 days prior. The footage from camera 2 was crystal clear. It showed the cement mixer pulling out of the muddy trench. As it reversed onto the asphalt, huge clumps of red clay fell from its tires. But that wasn't all. The video clearly showed Linda Halloway herself standing on the sidewalk directing the driver. She looked down at the mud, waved her hand dismissively, and pointed for the truck to leave. Arthur printed the invoice. He stapled it to a screenshot of the video showing Linda standing next to the mud. He placed it in a red folder labeled Damages, Punitive. That afternoon, the roofing crew arrived. They were tossing bundles of shingles onto the plywood sheathing. The thuds vibrated through the ground. Arthur walked out to the edge of his remaining lawn. The foreman, a man named Merriweller, who seemed to be the only one with a conscience, walked over. He looked uncomfortable. "Mr. Vance," Miller said, taking off his hat. "Look, I just build what they tell me to build, but I gotta ask, you know this thing is practically in your living room, right?" "I'm aware, Mr. Miller," Arthur replied, his face impassive. The lady, Mrs. Halloway, she was out here this morning. She told us to cut back those oak branches hanging over the roof. Said they were a hazard. Arthur's eyes narrowed. The oak tree, the one Jim Hansen had said was already dying from the root damage. Did you cut them? Not yet. I wanted to ask you first. Those look like they're on your side. They are, Arthur said. But don't let me stop you, Mr. Miller. If she gave the order, you follow it. Just make sure you get it in writing. Miller looked confused. You want me to cut your tree? I want you to do exactly what the HOA president tells you to do, Arthur said, turning back to the house. I wouldn't want to be accused of obstruction. Miller shrugged and signaled his crew. 10 minutes later, the chainsaw roared to life. A massive limb, heavy with green leaves, crashed down onto Arthur's lawn. Inside the house, Arthur watched the monitor. He saved the clip. He backed it up to 2 different hard drives. Destruction of timber. In their SOI, that carried a treble damages award, triple the value of the tree. A 60-year-old white oak was valued at roughly $20,000. Linda had just authorized a $60,000 mistake, and she had charged him $450 for the privilege. The structure was finished 2 days later. It stood complete, a monument to suburban overreach. Linda sent out an email, blast inviting the entire neighborhood to the grand opening ribbon cutting on Saturday. There would be balloons, punch, and a speech about enhancing our shared spaces. Arthur printed the invitation. He placed it in the folder. He picked up his phone and called Sarah. It's done, he said. The roof is on, the tree is cut. They're having a party on Saturday. I'll have the courier there by Friday afternoon. Sarah's voice was sharp, professional. Do you want to warn them? No, Arthur said, looking at the ugly gazebo casting a long shadow over his garden. Let them buy the balloons first. Friday afternoon arrived with a heavy, humid heat that promised a storm. The gazebo stood finished, draped in red, white, and blue bunting. A folding table had been set up inside it, ready for the punch bowls and cookie platters Linda had ordered. At 3 p.m., a silver sedan that did not belong to a contractor or a resident pulled up to the curb in front of Linda Halloway's house. A process server stepped out. He wasn't a mailman, he was a courier of consequences. He walked up the driveway, a thick manila envelope in hand, and rang the doorbell. Arthur watched from his window, sipping ice water. He didn't need to hear the conversation. He knew exactly what the paper said. Cease and desist immediately. Notice of intent to sue. Demand for preservation of evidence. Linda opened the door. Arthur saw her stiff posture, the way she snatched the envelope. She didn't open it immediately. She waited until the server walked away before tearing the tab. She stood on her porch, reading the cover letter. Even from across the street, Arthur saw the gesture. She crumpled the letter in her fist. She threw her head back and laughed, a sharp, dismissive motion, and tossed the ball of paper into her recycling bin. She didn't believe him. To her, Arthur was just a grumpy old man playing lawyer. She believed her title of president gave her immunity from the reality of property law. The next morning, the storm had held off, leaving the air thick and sticky. By 10 a.m., the cul-de-sac was full of cars. Residents from all 4 phases of Oak Ridge Estates were gathering. There was music playing from a portable speaker, some generic, upbeat pop tune. Arthur dressed carefully. He put on a crisp, button-down shirt and slacks. He wasn't going to hide in his house. He walked out his back door and stood on his patio, exactly 3 feet from the edge of the construction zone. Linda was in her element. She wore a floral dress and a wide-brimmed hat, holding a pair of oversized ceremonial scissors. She stood on the steps of the gazebo, steps that were resting on soil Arthur had paid taxes on for 2 decades. Welcome, everyone, Linda shouted, her voice shrill over the music. Thank you for coming to celebrate the opening of the East Side Scenic Overlook. This project has been a labor of love for the board, despite the challenges from certain non-cooperative elements. She cast a pointed look at Arthur. The crowd turned to look at him. Some faces were sympathetic, but most just looked awkward, wanting to get to the free cookies. But we persevered, Linda continued, because progress cannot be stopped by selfishness. This land belongs to all of us. Actually, Arthur said, he didn't shout, but in the sudden lull between tracks on the playlist, his voice carried clearly. It belongs to me. Linda's smile froze. Mr. Vance, do not cause a scene. We have already received your little letter. My brother-in-law is a paralegal, and he says you have no case. Now please step back, or I will call the police. You should call them, Arthur said, taking his phone out, because I'm about to. He didn't dial 911. He dialed the non-emergency line for the sheriff's department, a number he had saved. He had spoken to Deputy Miller earlier that week, explaining the potential for a civil disturbance. We are cutting this ribbon, Linda announced, turning her back on him. She grabbed the red satin ribbon stretched across the gazebo entrance. Snip. The ribbon fell. The board members clapped loudly. Linda stepped forward, crossing the threshold into the gazebo. Arthur raised his phone, recording the moment. Linda Holloway, he narrated calmly for the video, has just officially trespassed on Lot 44, despite written notice delivered yesterday via courier. The time is 10:14 a.m. Linda spun around, her face red. Get that camera out of my face. You are violating my privacy. There is no expectation of privacy in a public commission of a tort, Linda, Arthur said, and you are standing on my azaleas. A murmur went through the crowd. They were starting to realize this wasn't just a cranky neighbor dispute. Arthur wasn't yelling. He was documenting. A sheriff's cruiser turned the corner, lights flashing but siren off. The crowd parted. A deputy stepped out, adjusting his belt. Linda beamed. Finally, officer, please remove this man. He is harassing our event. The deputy walked past Linda. He walked up to Arthur. Mr. Vance, you the one who called about the trespassing? I am, Arthur said. I have the deed, the certified survey, and the cease and desist order that was served yesterday. Officer, Linda shrieked, I am the HOA president. This is common area. The deputy looked at the survey map Arthur handed him. He looked at the stakes Jim Hansen had placed, which Linda had kicked over, but whose orange spray paint marks remained on the grass. He looked at the gazebo. Ma'am, the deputy said, turning to Linda, according to this, you are about 8 feet onto this man's property. That map is fake, Linda spat. It has a raised seal from a state-licensed surveyor, ma'am, the deputy said, his patience thinning. I can't arrest you for a civil dispute, but I can tell you that if you don't step off this man's land, I can cite you for criminal trespass. The dispute is for a judge to decide, but right now you need to move. Linda looked at the deputy, then at the silent crowd. Her authority was cracking. This isn't over, she hissed at Arthur as she stepped off the gazebo and onto the safe grass of the true common area. No, Arthur agreed, his voice cold. It's just starting. You might want to save those cookies, Linda. You're going to need the money. The party dispersed in awkward silence. The gazebo stood empty, an occupied territory in a war that had just gone nuclear. The lawsuit didn't arrive as a single envelope. It arrived as a bombardment. At 9:00 a.m. on Monday, 3 separate process servers fanned out across the city. One went to Linda Holloway's home. Another went to the car dealership where Steve, the vice president, worked. The third visited the office of the HOA's treasurer. They were all handed identical packets. 60 pages of dense legal filings, bound in heavy blue paper. Arthur Vance versus Oak Ridge Estates Homeowners Association, et al. The et al. Was the knife in the ribs. It meant and others. In this case, it meant Linda Holloway, Stephen Miller, and Janice Kress were being sued not just as board members, but as individuals. By Tuesday evening, the emergency meeting at Linda's dining room table felt less like a strategy session and more like a funeral. The atmosphere was thick with panic. The cookies on the table went untouched. Sitting at the head of the table wasn't Linda, but George Henderson, the attorney on retainer for the HOA. He was a tired-looking man who specialized in collecting unpaid dues, not defending against 7-figure tort claims. He had the lawsuit spread out in front of him, his glasses perched on the end of his nose. Tell me again, Henderson said, his voice dangerously quiet. Tell me again about the permit. Linda crossed her arms, defensive. I told you, George, we filed for a Class B landscaping improvement. It was faster. We didn't need a survey. Henderson took his glasses off and rubbed the bridge of his nose. Linda, you built a permanent structure with a concrete foundation. That is a Class A structure. Filing for a Class B isn't a loophole, it's fraud. And because you did it to bypass the survey requirement, It shows willful intent to deceive. So what? Steve stammered, loosening his tie. That's why we pay for liability insurance, right? The director's and officer's policy covers legal mistakes. Henderson looked at Steve with pity. Insurance covers negligence, Steve. It covers accidents. It covers, oops, we hired the wrong guy. It does not cover intentional illegal acts committed after receiving a formal cease and desist order. The room went deadly silent. The grandfather clock in the hall ticked loudly. What are you saying? Janice the treasurer whispered. I spoke to the insurance carrier this morning, Henderson said. They are issuing a reservation of rights letter. They might pay for your defense initially, but if a judge finds that you acted with malice or gross negligence, which, given the video evidence of you ignoring the boundary markers in the police, is highly likely, they will deny the claim. They won't pay a dime of the judgment. But how much is he asking for? Linda asked, her voice finally losing its edge. Henderson flipped to the last page of the complaint. Restoration of land, $40,000. Statutory damages for timber trespass, $60,000. Legal fees, currently $15,000 and climbing. Diminution of property value, $100,000. He paused. And he is seeking punitive damages for harassment and emotional distress in the amount of $250,000. He can't do that, Linda shrieked, slamming her hand on the table. He's just one old man. He is an old man with a 40-year career in land law and a daughter who is a partner at a litigation firm, Henderson snapped. He isn't suing the HOA for the punitive damages, Linda. He's piercing the corporate veil. He's suing you. Steve stood up so fast his chair tipped over. Me? I didn't cut the tree. I didn't tear up the letter. That was her. He pointed a shaking finger at Linda. You voted for it, Steve, Henderson said coldly. It's in the minutes. Motion to proceed despite neighbor objection. Seconded by Steve Miller. I have a mortgage, Janice said, tears welling up. I have 2 kids in college. If we lose, if the insurance doesn't pay, then Mr. Vance can place a lien on your personal assets, Henderson finished. Your cars, your savings accounts, your homes. Linda looked around the table. The sycophants were gone. In their place were terrified people realizing that their leader had led them off a cliff. We fight it, Linda said, though her voice trembled. We go to court. A jury will see that we were trying to improve the community. No jury will bankrupt us for building a gazebo. Henderson began packing his briefcase. Arthur Vance doesn't want a jury, Linda. He asked for a summary judgment hearing. It's just going to be a judge, the law, and the maps, and right now the maps say you're trespassing. He stood up and looked at the terrified board. My advice? Resign. Settle. Beg him to drop the personal suits. Because if this goes to court next month, you aren't just going to lose the gazebo. You're going to lose everything. Henderson walked out. Linda sat alone at the head of the table. For the first time, she wasn't thinking about the bylaws or the power. She was thinking about the video Arthur had taken of her standing in the mud. She realized with a sinking horror that the mud was about to bury her. Across the street, the lights in Arthur's study were still on. He wasn't sleeping. He was preparing. The Honorable Judge Evelyn Caldwell was known for 2 things. She hated wasted time, and she had a zero-tolerance policy for sloppy paperwork. Her courtroom was cold, quiet, and smelled of lemon polish. On the left side of the aisle sat Linda Halloway and the entire HOA board, squeezed together like nervous schoolchildren. They were dressed in their Sunday best, but the tension was palpable. Steve kept wiping his palms on his trousers. On the right side sat Arthur Vance and his daughter Sarah. Their table was uncluttered, just a single laptop and 3 large rolled tubes of paper. Judge Caldwell adjusted her glasses and looked down at the docket. Case 24-4 Vance versus Oak Ridge Estates HOA. We are here on a motion for summary judgment. Mr. Henderson, you represent the defense? I do, Your Honor. George Henderson stood up. He looked like a man who knew he was holding a losing hand, but had to play it anyway. And the plaintiff is represented by Ms. Vance. The judge raised an eyebrow. Yes, Your Honor. Sarah stood, confident and sharp, with my father, Arthur Vance, acting as expert witness for the survey data. Very well, proceed. Henderson tried his best. He argued that the encroachment was de minimis, too small to matter. He argued that the HOA acted in good faith to improve the community. He argued that tearing down the structure now would be an undue burden on the association's finances. It was an honest mistake based on digital records, Henderson pleaded. There was no malice intended. No malice, Sarah stood up. Your Honor, I'd like to submit Plaintiff's Exhibit C, a video taken on May 12th. The bailiff played the video on the courtroom monitors. It showed Linda Holloway standing on the porch, crumpling the cease and desist letter and laughing. It cut to the deputy warning her. It cut to her ordering the tree to be felled. The courtroom was silent. Judge Caldwell's face hardened. Mr. Henderson, the judge said, her voice icy, your client received a legal notice of encroachment and responded by laughing? It was a stressful moment, Your Honor, Henderson stammered. Let's talk about the land, the judge turned to Arthur. Mr. Vance, you claim the structure is on your property. The defense claims their GPS data says otherwise. Arthur stood. He didn't look like a victim. He looked like a professor. He walked to the easel and unrolled the first map. Your Honor, GPS on a phone has an accuracy of roughly 3 meters, Arthur explained, his voice steady. That is 10 feet of error. In surveying, 10 feet is the difference between a fence and a felony. He pinned up the second map, the certified forensic survey from Jim Hansen. This is a robotic total station survey, close to a precision of 1 in 50,000. It shows the iron pins I set in 1998, which were recovered last week. The scenic overlook is not just encroaching. The entire foundation lies 7 feet, 4 inches across the boundary line. He pinned up a third document, a blown-up photo of the construction permit. And this, Arthur pointed, is the permit application signed by Mrs. Holloway. She certified that no survey was needed because the work was landscaping. A concrete slab is not a petunia, Your Honor. Linda Holloway let out a gasp. We didn't. No. Silence! Judge Caldwell slammed her gavel. She stared at Linda. Ignorance of the law is not a defense, especially when you are the president of a corporation enforcing those laws on others. You bypassed the permit process to save money. You ignored a neighbor's warning. You ignored a police officer. The judge turned back to the files, writing furiously. The sound of her pen scratching was the only noise in the room. I have heard enough, Judge Caldwell said, looking up. The facts are not in dispute. The structure is illegal. The trespass is proven. The malice is evident. She leaned forward. I am granting summary judgment in favor of the plaintiff. The HOA is ordered to remove the structure immediately, not in months, but within 14 days. You will restore Mr. Vance's land to its original condition, including the replacement of the mature oak tree with a specimen of comparable size and value. Steve groaned audibly. Furthermore, the judge continued, I am awarding treble damages for the timber trespass. That's $60,000. And due to the willful nature of the act, I am piercing the corporate veil. Linda's face went white. The punitive damages of $200,000 will be levied against the HOA. However, if the HOA's insurance denies coverage due to your negligence, which I suspect they will, the individual board members named in this suit will be held jointly and severally liable for the remainder. Your Honor, please, Linda cried out. That will bankrupt us. You should have thought of that before you built a gazebo in another man's backyard, Mrs. Holloway, Judge Caldwell said, closing the file. Court is adjourned. Arthur didn't smile. He didn't cheer. He simply capped his marker, rolled up his maps, and looked at Linda one last time. She was slumped in her chair, weeping. He walked out of the courtroom, Sarah by his side. Coffee, Coffee? Sarah asked. Coffee, Arthur agreed, and maybe a donut. I have some demolition to supervise next week. 2 weeks after the gavel fell in Judge Caldwell's courtroom, the heavy machinery returned to the cul-de-sac. But this time, the rhythm of the engines felt different. It wasn't the aggressive roar of conquest. It was the grinding, mechanical sound of retreat. Arthur sat in his wicker rocking chair, the same spot where he had sat during the pouring of the concrete. He held a fresh cup of coffee, the steam rising in the crisp morning air. Across the property line, a demolition crew was dismantling the East Side scenic overlook piece by piece. The shingles were stripped first, sliding down the roof like shedding skin. Then came the framing, the pressure-treated lumber splintering under the force of crowbars. But the real drama wasn't happening on the construction site. It was happening in the street. A group of neighbors had gathered. They weren't there to admire the view. They were holding papers, bright pink notices that had been taped to every mailbox in Oak Ridge Estates the day before. Notice of special assessment. Due to an unfunded liability judgment against the association, each homeowner is hereby assessed a one-time fee of $3,200 payable immediately. The insurance company, as predicted, had denied the claim. The cost of Arthur's damages, the legal fees, the demolition, and the punitive fines had drained the HOA's reserve fund dry. The bill for Linda's arrogance had now come due, and it was being split 50 ways. Linda Holloway was nowhere to be seen. Her blinds were drawn tight. Her car was in the driveway, but she wasn't coming out. She had resigned via email 3 days ago, hours before a recall petition with 90 signatures would have forcibly removed her. "Careful with that truss," the foreman shouted. A massive section of the roof collapsed inward with a satisfying crunch. Dust billowed up, a cloud of drywall and insulation that drifted over the fence and settled on the common area sign. Arthur watched it all with a clinical detachment. He didn't feel joy in his neighbors' financial pain. Many of them were good people who had just been too passive. But he felt a profound sense of order being restored. The universe had rules. Geometry had rules. And when you tried to bend them to fit your ego, they eventually snapped back. Around noon, a flatbed truck arrived carrying the final piece of the court order. It was a massive white oak tree, its root ball wrapped in burlap the size of a Volkswagen. It was an expensive specimen, sourced from a specialty nursery 2 counties over, paid for by the personal liens placed on the former board members' assets. The crane lifted the tree into the air. It hovered for a moment against the blue sky, a suspended symbol of restitution. Then, slowly, gently, it was lowered into the fresh crater where the gazebo's foundation had been jackhammered away. Arthur took a sip of his coffee. It tasted perfect. His phone buzzed. It was a text from Sarah. "Mom says you should stop gloating and come inside for lunch." Arthur smiled. He wasn't gloating. He was inspecting. He watched the crew tamp down the soil around the new tree. He watched them smooth the dirt, covering the scars of the last 2 months. He watched the property line return to exactly where it had been in 1998, invisible to the naked eye, but as solid as iron in the eyes of the law. The gazebo was gone. The board was gone. The noise was fading. Arthur stood up and stretched his back. He looked at the spot where the intruder had stood, now just a patch of fresh dirt in a majestic new tree. "Good fences make good neighbors," Arthur whispered to himself, quoting the old poet. "But good surveyors make sure the fence is in the right damn place." He turned and walked back into his house, closing the door firmly behind him. The show was over. The land was his again.